lost marginally under half an hour, Mr. McLean, so what we suggest is that we, having had the break really, if it's not too much of a strain on, we sit through till 1 o'clock. And then if we start again at 1:45, yes, we're going to go on till 5 anyway. And so break in the afternoon, assuming there isn't yet another incident or something. I don't know what it was, probably somebody said, probably somebody left a toaster on or something.
Yes, I'm reminded that during the course of the trial, I was cross-examining one of the witnesses, and the fire alarm went off, so maybe it's me. No.
Doubtful.
Can I see the fact that 4G pricing and limiting supplies to indirect retailers formed part of a composite concern to preserve value in the market is clear from the evidence in relation to the landmark lunch, which I've already shown the court, which is at paragraph 58 of the learned judge's judgment on page 307 of the bundle. And the court has already seen this, but it's very clear in our submission. You see it starts off in the first sentence, at the lunch with Ronan Dunn, he raised a concern about value in the market and concerns about the pricing strategy behind 4G, keen to emphasise the opportunity to establish a pricing structure that recognises its enhanced value. In other words, premium pricing. He raised a difficult scenario whereby discounting on 3G by other competitors or other retail channels could lead to a reassessment of the premium pricing, particularly acute with the indirect channels, and an excess of supply contributed to that risk. He appeared to suggest you believe that such discounting could be de-risked if that excess of supply was dealt with in some way. He talked about making some unilateral steps, cards, and then we have...
The real point was that they wanted to get, he at least wanted to get indirect suppliers out of the picture. Because the concern was that if they introduced 4G at a premium, which they wanted to do,
yes,
let's just say the actual phone company,
yes,
the indirects would simply undercut the price on 3G.
Yes.
And a lot of people would have been quite happy just to continue with 3G.
Yes.
Especially given that most of the country can still only get 3G even now.
Indeed. Now, my Lord the Chancellor asked about whether 158 set out the whole of the document, and you notice that there's another paragraph, 177, that continues it. And just give you the reference for the whole document in the bundles.
Yeah.
And that's supplemental bundle 2, tab 39, pages 829 to 830. We needn't turn it up.
Okay.
Now, if we then turn to paragraph 195 of the learned judge's judgment, on page 316, and if I could invite the court to read from I reject Mr. Dunn's evidence down 5 or 6 lines to likely to be led by the indirect retailers.
Yeah.
So the same point, paragraph 197 of the judgment, 317.
Well, he also says that it tied in with the 25th of October.
Yes. Yeah, exactly. 197, you can see about halfway down on the paragraph, the judge says, on balance, I consider he was sounding out Mr. Swanty to see whether if O2 reduced its reliance on the indirect channel, EE might support that move to, quotes, preserve value in the market. And this concept of preserving value in the market is intimately connected with 4G pricing, but also the other side of the coin is reducing reliance on indirects. And we also, now if we turn to judgment 164, this relates to Mr. Swanty being approached by others, Mr. Lawrence, Mr. Harrison, the Cariff Carphone Warehouse. Could I ask you just to read to yourselves paragraph 164 and 165?
Yeah.
Now, one sees that just as at the landmark lunch, there was a concern about value in the market, which would be eroded, and they were concerned to prevent or avoid, if they could, discounting by the indirects. Now, as far as the approach by Lawrence to Swanty is concerned, Vodafone submits that these approaches were not really linked, because Lawrence didn't refer to weakening indirect distribution when he spoke to Swanty, and indeed appears to have coordinated his approach to Swanty with an indirect distributor, i.e. Carphone. Now, it seems to be the submission that if Lawrence was prepared to collude with the assistance of an indirect distributor to boost prices, he'd be far too loyal to the indirect sector to involve in any attempt to secure the same goal by weakening the indirects. But on its face, that's a ridiculous submission. It also disregards the fact that it's common ground that Mr Dunn was involved in both approaches, once at the landmark lunch, and secondly, having spoken to Mr Lawrence at a private meeting, which left no record. Mr Dunn's involvement in price fixing appears at judgment 237 and 238 on page 329 and 30 of the judgment. So, Dunn's got a good relationship with Lawrence. The judge finds that the calls in relation to 4G, 238, were coordinated. But then he goes wrong in our respectful submission in the following paragraph. However, the subject of those phone calls was 4G pricing. And then he sets out a summary of our submissions. But in my submission, the learned judge fails to have regard to our submissions on the close connection between 4G pricing and O2's contemplated action against the indirects. Now, I'm not going to turn it up now in view of time, but at tab 137 of the supplemental bundle on page 517, we do make the point in written closing that there was such a close relationship. But whether or not the judge paid attention to our submissions or had them in mind, his consideration of the issue in my submission proceeds on the mistaken basis that 4G pricing and supplies through indirects were discrete and distinct topics. Two topics were closely related and effectively represented in my submission. The same issue, and we respectfully suggest that the approach that the learned judge took is an example of compartmentalisation. I then turn, my lords, to the Whiting note. Now that, perhaps the court should have that up. It's a core supplemental bundle, tab 22, page 68. Now, the court has seen this before, and on its face, it was obviously a document which was important to Phones for Use case, in which it relied on heavily, unsurprisingly, in view of what it said. Now, by the end of the case, there had been, in our submission, a significant accretion of further evidence, which reinforced the existence of anti-competitive contacts between the MNOs, which influenced their decision-making as far as Phones for Use is concerned. As the judge noted in paragraph 284 to 285 of his judgment, Mr. Dunn emphatically denied, when he was asked about this, having said anything of the sort. And you see that, judgment 284, 285 on page 342. and you see he said it was nonsense. And then you see that the submissions made by Telefonica and Phones for You submitted, the court had to decide which version of the conversation to believe. And we set out a series of factors as to why the evidence of Dunn, or conversely Whiting, should be preferred. Telefonica, for its part, brazenly accused Mr. Whiting of having fabricated this contemporaneous evidence. We each, as I've said, submitted that the court had to decide which version of the conversation to believe. And the learned judge came to decided in favour of Phones for You. But the important point is no one suggested in cross-examination, Mr. Dunn, or even in opening submissions, that Dunn did indeed say what the note records him as having said, but that he was telling lies when he said it. Despite this, Vodafone's counsel in closing submitted that the court should find that Mr. Dunn, if the court found that Mr. Dunn did say what the note records him as having said, the court should also find that he made it up.
Was it, sorry, just so I understand that, you were saying it was not put to him in cross-examination that he'd made it up?
No. No. Well, they had opportunity to do it, they didn't. And that is the course one sees in paragraph 3.
Sorry, so it was raised in closing? It was raised in closing?
It was raised in closing.
Yeah.
For the first time. And you see that from paragraph 310 of the learned judge's judgment on page 349. So that's what the judge finds as the likely explanation. Now, in our submission, in reaching that conclusion, the learned judge adopted an improperly compartmentalised approach, which is problematic whether you consider it under ground 4 or under ground 5, but for convenience I'm dealing with it here under ground 5. First, on the judge's own findings, what Mr. Dunn actually said about Mr. Swanty's position was something that he could fairly have said. And perhaps if we have the note back up on the screen, core bundle, supplemental bundle, there we are. You'll see that the last sentence, he went on to say that he was less sure of the intentions of EE with respect to independent distribution because Olaf Swanty was not inclined to discuss EE's distribution plans. Now, when we go back to the judgment at 307 subparagraph D, paragraph page 348, you'll see that the judge says, if as Mr. Hoskins submitted, Mr. Whiting fabricated this account to excuse his inability to reach an agreement on behalf of Phones for You with O2, I find it extraordinary that he would have included the fact that Mr. Dunn said he was less sure of the intentions of EE with respect to independent distribution because Swanty was not inclined to discuss EE distribution plans. That was completely irrelevant if this was Mr. Whiting's motivation. But something that Mr. Dunn could fairly have said, given his experience and Mr. Swanty's discussed above. Now, but having relied on that as being something Mr. Dunn could fairly have said in support of the proposition that the note wasn't fabricated, having made a broadly accurate statement in relation to Swanty, it is, in our submission, surprising that he would have yoked together with that true statement something which was untrue. There was, in our submission, no reason to tell the truth about EE, but lie about Vodafone. Nor indeed was there any reason to invent a story that implicated both Vodafone and Telefonica in collusion, when Mr. Dunn could simply have said the decision to exit Phones for You had been taken over his head and it wasn't in his gift to change. Now, the fact that the statement was at least partly true must, in our submission, have increased the probability that it was not some bizarre flight of fancy on the part of Mr. Dunn. And the other evidence that the learned judge did not appear to consider in this context was the fact that it emerged in the course of the case. Just pausing there, my lords and my lady, we had the Whiting note at the outset of the case. So that That was internal to Phones for You. That was their document. But during the course of the trial, we got disclosure, and we got this scrappy handwritten note of Mr. Hum's under the heading UK out distribution, which I talked about, which I made submissions about yesterday. It emerged that two of the individuals, if we go back to the note, called Supplemental Bundle 68, tab 22, if we go back to the note, two of the individuals, Miss Sands and Mr. Hum, we actually discovered had actually met in September 2013, a few short months before Mr. Dunn actually made this statement to Mr. Whiting. And the learned judge found that in the course of that apparently unique meeting, according to Miss Castillo, the two executives specifically identified by Mr. Dunn, according to this note, had indeed discussed supplies by O2 to Phones for You. And we can see that at the learned judge's judgment at 288 to 290. If I could invite the court to read those paragraphs.
Yeah.
Now, you'll see in 291, if we scroll a bit more, he says, however, although I find on the balance of probabilities this matter was raised, that's a very different thing from Ms. Castillo making a commitment to Mr. Hum that O2 would fully exit Phones for You. But he makes that finding without having regard to the fact that he has, or will also conclude, then Dunn did indeed say the things that are recorded in the Whiting note. Now, it may be that because the judge first concluded that nothing unlawful was said in the conversation between Hum and Castillo, that he then came on to consider the note. But if the judge had considered this evidence in the round, rather than asking first whether commitments were given, and then in light of that conclusion, whether Dunn was telling the truth, he must surely have been struck by the inherent unlikelihood of Dunn having told a lie that so closely mirrored the true facts that he, Dunn, had no reason to know. In effect, the judge's approach of addressing the truth of what Dunn had said only after having considered the events in isolation meant that he disregarded the inherent probability of Dunn having, in the course of making up excuses, having stumbled so closely to the mark in relation to a discussion between Hum and Castillo. In our submission, it's likely that Mr. Dunn said what he did because it was at least broadly true. Now, Vodafone, in response to our submissions, suggests that it is now common ground that Mr. Kalau, who is also referred to in the note, if we turn up the note again, Mr. Kalau, they say it's common ground that he didn't give any commitments to Alerta, Telefonica, such that at least part of what Dunn told Whiting was false. And that's paragraph 166 of their submissions. But there are a number of problems with that submission. First, it's not common ground that Kalau did not have a collusive discussion with Alerta. Phones for You failed to prove its case to that effect at trial, not least in circumstances where Mr. Alerta himself did not give live evidence at trial, and furthermore, where Telefonica had given almost no disclosure. Given that evidence of illicit collusion is likely to be fragmentary and sparse, it's fairly remarkable that Phones for You obtained relatively direct evidence of the content of the discussion between Hum and Castillo, and that's that scrappy handwritten note out distribution. It would be a 1,000,000 to 1 shot to also have documentary evidence of a similar discussion between Kalau and Alerta. The lack or non-survival of such evidence does not mean that Dunn wasn't telling the truth. And I should also note that Vodafone did not put to Dunn that any part of what he said to Whiting was a lie, let alone that he was specifically lying about the contact between Colau and Alerta. That is not a promising start for a submission on appeal, that it should be treated as common ground that Dunn lied about the contacts. Phones for You's position would be on a retrial that if the judge's other findings on the Whiting note have been reconsidered, that has knock-on consequences for whether what Dunn said about the contacts between Colau and Alerta should be reconsidered as well. The fact that from the starting point of his other findings, the judge didn't find that Alerta and Colau engaged in collusive discussions can't be converted into some sort of bulletproof positive finding, regardless of what else might be found as to the truth of those communications.
Well, the inherent probability, really, that either everything that was in the note was true,
yes,
or that, at least in one or more respects, Mr. Dunn was mistaken for some reason because he misunderstood something that he picked up
yes,
within the Telefonica camp, as it were.
indeed.
But the idea that some of it's true and some of it's a barefaced lie is not really a very probable conclusion, is it?
Indeed, man, what it is not.
I mean, one looks at people's motivations for doing things. It's a pretty odd motivation. I'm going to tell the truth about X and lie through my back teeth about Y.
Indeed, and he did. Well, that's where we are, and those are my submissions. Can I then turn to my final point on compartmentalisation, and that is the position as regards EE and Vodafone in 2014. And this relates to the business review meeting, which was held at EE on the 21st of May 2014. This is partly a Ground 4 point, but it also conveniently can fall within Ground 5. It was an important meeting on the 21st of May, dealing with the course of EE's decision-making about Phones for You. The judge found that it was at this meeting that EE decided to pursue an enlarged deal with Carphone Warehouse and to consider whether to reduce its footprint in Phones for You or exit Phones for You altogether. Judgment references 516 and 531. Now, what is important in this context is a document which I'd like the court to look at. Supplemental bundle, tab 87. Yeah. Forgive me. Perhaps I can deal with it on the screen. This is another of those documents written by Mr. Stephen Harris. The court may recollect. I showed the court the business review meeting from the 20th of March.
So can I just get the reference?
Forgive me, my lord. It is supplemental bundle, tab 87, page 1232. And what I'm interested in is this. If we scroll on to page 1235, keep going, we see at the bottom of the page, indirect distribution update. Now, as I've said, this is where the judge, this is the important meeting at which the judge found that there was a decision to go with Carphone Warehouse and potentially to exit from Phones for You. And if we scroll down a bit further, we'll see that nothing is recorded in that regard. Phones for You alleged that this showed that Mr. Harris had at least concluded that some of what was said in the discussion about indirect distribution might be better kept unrecorded. Of course, Phones for You could not know precisely what Harris had not recorded. It'd be impossible to know whether he chose what he chose not to record was direct evidence of collusion or something that he was concerned might lead a trail of inquiry towards. But because he didn't make a record, we'll probably never know. Now, I should note in this regard that there was a handwritten note relating to this meeting authored by Monsieur Deloison of Orange. But when you come to read Orange's submissions, they are wrong to say that he attended the meeting. He did not. And the judge in paragraph 532, subparagraph A1, on page 412, records that Monsieur Deloison did not attend. But that doesn't matter. Just a point of accuracy in Orange's submissions. Monsieur Deloison, yeah, there we are. Mr. Deloison wrote a note, summary of justice. He'd not been at the meeting. So he made a record of some of what was said to him by someone who had been at the meeting. But that doesn't really advance what it was that Mr. Harris did not record, or what the minutes would have said had they been properly written. It was EE's sanction. Now, the judge, we alleged that it was a deliberate decision not to make a record, and the judge rejected that. Judgment 593 to 597. Now, we say that was a surprising conclusion, but we do not say that it was perverse. But what we do say, if the judge was going to adopt this approach, he had to consider the evidence which went the other way. And he did not consider it in relation to this matter evidence which cast a light on Mr. Harris's past practice in compiling minutes. And this included evidence that neither Harris nor Milson could recall Mr. Harris ever having failed to record the content of the BRM meeting in this way. And we give the references for that in our appeal skeleton, paragraph 71, which are 171, that's on page 71, which I don't ask you to turn up at this stage. More importantly, what the judge failed to have regard to is what happened after a recent meeting. And if we could please have core supplemental bundle, tab 24, page 71. This is an email sent by Mr. Harris on the 31st of March to Wolfgang Knieser and Christophe Nolot, respectively of Deutsche Telekom and Orange. And you will see that in the last paragraph, he says, unrelated, James is currently checking the minutes of the last BR, board meeting, business review meeting, forgive me, and as soon as he has, I will release. I'm just being extra cautious given the topic above. And what's the topic above? Indirect. Next steps. The James, who is referred to there, is Blendis, EE's general counsel, who had not attended the meeting. These were internal minutes, not for public consumption or publication. And as you see, the thought that Mr. Harris had was that he was being extra cautious given the topic, indirect next steps. Now, I asked some questions of Mr. Harris about this, which we can see if we look at, if we turn on to tab 51 in this bundle, page 134. And this is on page 1439. My cross-examination starts at page 9 internal, and I'm asking about this letter and what he was planning to do. I say to him, you weren't expecting him to check the spelling or grammar of your minutes, were you? No, I wasn't. How could Blendis contribute in any meaningful way to a verbatim record of a meeting that he did not attend? Can you explain that, please? my only reason for asking James, if I wanted to check a legal point. You wanted to check a legal point. Mr. Blendis, let's assume that Mr. Blendis did not attend the meeting. Okay, yes. And your notes had set out what individuals had said in relation to the various subjects which were discussed, correct? Yes. And the topic you seem to have been particularly concerned about, which was making you extra cautious, is subject matter indirect, next steps. I honestly can't remember what the point was, so it could have been indirect, it could have been something else in the minutes. Well, you see, you say in the last paragraph, I'm just being extra cautious given the topic above. So it looks like the topic above, indirect next steps, is what was making you extra cautious and was leading you to request Mr. Blendis' review of the minutes. Is that right? Yes, it would appear so, but I don't recall making that note. Yes. No, just what were you expecting Mr. Blendis to do by way of checking in relation to a meeting which he had not attended? I may well have asked James if there was a point that had been inappropriately captured from a competition law point of view, but I can't honestly remember why I asked James the question. Now, if one asks oneself, who might, when you want to consider whether something's been inappropriately captured from a competition point of view, what prying eyes might you have in mind in relation to these minutes? Might it be the regulator who might be interested in your decision making? Might it be the potential victim of collusion? Our simple point, if the judge was going to reject Claimant's case, that Harris had deliberately left out material which was potentially problematic from a competition law point of view in the minutes, he had at least to deal with evidence. Mr. Harris had at least considered doing that, exactly, for the March BRN. We say that this is a paradigm example of evidence that at a minimum ought to have been taken into account. Now, that, as I say, could be a ground 4 point, could be a ground 5 point, it doesn't matter. And I then move on to a...
Did you put to Mr. Harris that I think you did, I think you told us you did, that the absence of anything in the minutes under indirect distribution updated the 21st of May
Yes.
was a deliberate
Yes.
excision of some material that would have been incriminating?
Yes, I did.
Was that put to Mr. Blendis as well?
I cannot honestly recall my note. I'm sure
I mean, it may or may not matter.
we'll look. And
But if he put it, if Mr. Blendis was asked to look at the earlier minutes, one might think he was asked to look at these minutes as well.
Yeah, if I may, I'll have a look, and I'll tell the court this in reply.
Okay.
Now, coming to what we say is an example of compartmentalisation, despite what the learned judge said in refusing permission, I want to turn again to that part of the judgment where he deals with a series of what he describes unfortunate events. And if you could please turn to judgment 615. Sorry, wrong. Paragraph 609 to 615, forgive me. And this is the meeting which took place with Ofcom, and may I invite the court to read 609 through 615.
Yeah.
So, the long and the short of it is that Mr. Harris participated in EE's efforts to present the regulator with a picture of its decision-making that would allay suspicions over potential coordination with Vodafone, which was seriously misleading. Specifically, the Ofcom was seriously misled as to the timing of EE's key decision-making in relation to supplies to indirects, because the decision was then moved back by what they were being told from May to March. That might make all the difference if the goal was to discourage Ofcom from investigating for any other evidence of collusion between EE and Vodafone in April or May 2014. Now, at paragraph 615 of the judgment, you'll see that the judge makes clear that he had asked himself whether this deplorable episode had caused him to revisit a provisional conclusion that EE had not colluded with Vodafone. But what he failed to do was to consider whether Harris's preparation of an incomplete minute of the 21st of May in this context. There was, after all, conduct in relation to documents covering precisely the same issue, incomplete minutes, namely EE's decision-making on supplies to indirect retailers in the first half of 2014. If we stand back, the judge's approach meant that he never confronted the full picture in relation to Harris's preparation of documents relating to EE's decision-making in relation to indirects. And if he had done so, you'd have seen what we submit as a striking pattern of conduct. First, Harris had been interested to review his draft minute for the March BRM to potentially remove something inappropriately captured from a competition law point of view, something that related to EE's next steps in relation to indirects. Second, the minute for the May BRM simply missed out that topic altogether. Third, he presented the regulator with a misleading account to the effect that EE had adopted a strategy in principle of having Carphone as its main partner at the March BRM rather than the May BRM, as was in fact the case. In our respectful submission, the learned judge fell into a serious error by essentially considering the second of those two episodes of document production in isolation from the others. And my lords, that is all that I have to say in relation to ground 5. I'm going to hand over to Mr. Draper, who's going to deal with document construction. But before I do so, can I put down a marker in relation to something we're going to hear from Mr. O'Donoghue on Friday, and that relates to the application to put in further submissions. I make 3 very brief points. 1, it's far too late in breach of the practice direction. 2, if it was a point with any merit, it would require a respondent's notice, and there is none. And 3rd, as it's not adopted by any of the other respondents, that is a clear insight into its lack of substance. But obviously, if the court gives permission, I'll respond in due course. Now hand over to my learned friend, Mr.
Yeah. Yes, Mr. Draper.
We'll just reorganise if we may.
Yeah.
My lords, my lady, in the time remaining, I shall address ground 7, document destruction. The focus of these submissions will be on the 2 Telefonica parent companies, which I'm going to refer to together as Telefonica. I propose to structure my submissions on that in 3 parts. First, I shall address you very briefly on the importance of document preservation to the private enforcement of Article 101. Second, I shall summarise Telefonica's key failings in relation to document preservation. And then third, and most substantially, I shall address the error in the judge's approach to this issue, and in particular to the question of whether the destruction was deliberate in the relevant sense. On the first topic, in paragraphs 84 and 85 of the judgment, the judge refers to 3 authorities that we submit are relevant to the court's approach to document destruction in an Article 101 case. They are the judgments in Aalborg, Portland and Deturus, and the Advocate General's opinion in T-Mobile. 2 points in our submission are clear from those authorities. First, that undertakings involved in collusion are unlikely to make and retain much by way of documentary evidence of illicit contacts between them. Any documents that are generated are unlikely to survive and such as that do survive are likely to be fragmentary and sparse. Second, the court must be prepared to draw inferences from coincidences and indicia to complete the picture, and must not impose an excessively difficult hurdle for claimants to overcome. In that context, my learned friends for Telefonica submit that in circumstances where colluders are unlikely to have generated and retained documents in the first place, issues as to document preservation in this case are, quote, unlikely to have had any practical impact. That's from paragraph 38 of their written closing, which is effectively incorporated into their appeal skeleton at para 69, which is core bundle, page 194. We say that on the contrary,
other
context...
solutions on the other grounds, then that point loses quite a lot of its force, doesn't it? Because there is, or there are, a series of, on your case, fragmentary references, which, when you put them together, amount to a case of collusion, and the judge has failed to recognise that. And that's the case that Mr. McLean's been addressing.
Entirely.
And experience suggests that quite often the documents that survive may not be intended to survive, and they do survive somehow, and they give a particular picture.
Well, those that remain have to be seen all together, and coincidences in indicia identified, and the threads pulled together entirely. We say that on the contrary, in any event, in a context, as my lord has said, where the direct evidence may be fragmentary and sparse, document preservation may be all the more important. If those crucial fragments are to survive, such that there are enough to be drawn together, it is essential that defendants, once on notice of intended proceedings, take effective document preservation steps. Horses that have already bolted may be irrecoverable, but the claimant is entitled to have the gate shut and locked once the defendants are on notice. I can move then to Telefonica's failings, my second topic. As we note at paragraph 202 of our skeleton argument, the inadequacy of the document preservation can be seen in this way. The two Telefonica companies between them disclosed 389 emails. That is out of a total of around 74,000 or so emails disclosed by the defendants as a whole. And it's clear from the explanations that have since been provided by Telefonica that at least a major reason for this marked disparity is that they committed early to a course that was inherently bound to result in the loss or destruction of potentially relevant documents. And I shall come on to submit that this was plainly deliberate. The course was set, my lords and my lady, in mid-2015, when, after receiving detailed pre-action correspondence that included a request to retain potentially relevant documents, Telefonica's general counsel, worth noting that, their general counsel, Ramiro Sanchez, took a positive decision not to put in place any wide-scale document preservation measures. One consequence of that was that no substantial steps were taken to preserve the documents of Mr. Alierta, the CEO. Of course, it wasn't only Mr. Alierta. I'm going to focus in my submissions on him and what the learned judge says about his documents, because that was the focus of the judge's reasoning on this point. But also other disclosure custodians were important including in relation to what Mr. Alierta had done and what he knew. We've seen how, for example, an email between Miss Talbot of EE and Mr. Eyre of EE in our submission sheds a lot of light on what Mr. Milsom knew. We can turn then to paragraphs 56 and 57 of the judgment, please, which is core bundle page 276. This is the main place in which the judge deals with document destruction. And if you see around 2/3 of the way down paragraph 56, on the 30th of April 2015, Phones for You solicitors wrote a detailed pre-action letter to both Telefonica and Telefonica SA and Telefonica Europe, particularising allegations of anti-competitive collusion and expressly referring to alleged commitments given by Mr. Alierta and Ms. Castillo-Sanz, two individuals at Vodafone. That letter referred to the earlier request addressed to O2 and stated, please confirm by return that Telefonica has taken all reasonable steps to preserve documents which are relevant to the matters raised in this letter before claim. And as the judge notes, it appears that the letter did not reach the companies until mid-June 2015. Can I ask you, my lords and my lady, to then read to yourselves paragraph 57? Now that was in the face of detailed pre-action correspondence from Quinn Emanuel, a very lengthy letter that in substance, amongst many other things, set out what we now see in the Whiting note, and as the judge notes, directly implicated two named individuals. The letter sent on instructions from administrators is obviously an extremely serious matter. Now, during these proceedings, Phones for You solicitors unsurprisingly chased Telefonica for a proper account of its document preservation measures, and in response to those detailed questions and complaints, Telefonica's explanations ultimately came not from anyone with first-hand knowledge, but from, as you'll have seen from the judgment, Miss Nicola Bridge, partner at Mishcon de Rea. Now, Miss Bridge, of course, wasn't involved in any of the relevant decisions. She said, on instructions, and without waiving privilege, that Mr. Sanchez and other unidentified individuals at Telefonica had considered in 2015 that the allegations raised in the detailed pre-action correspondence were, quotes, spurious and without merit. The reference for that is paragraph 19 of Miss Bridges' witness statement, which is at supplementary bundle, tab 24, page 552. And you'll have seen it echoes fairly closely what we see at paragraph 57, back in the judgment at page 276, in the letter of 11th of February 2020. As I've said, and as we said to the learned judge, nobody with first-hand knowledge was prepared to come to court to stand behind the explanation or excuse that you see in that letter. Nobody took on the burden of trying to defend the idea that the 2015 decision was really motivated by concern about wasting time and money on a legal hold. So no one was at trial to meet the allegation that the 2015 decision was instead motivated by an appreciation that Phones for You's case, as set out in detail, whatever else was thought of it, would likely be made stronger, not weaker, by proper document preservation measures being put into place. Now, if Mr. Sanchez or anyone else had been prepared to stand behind the account of the 2015 decision, they would have had to answer, amongst other things, the point that where a corporate entity with a turnover measured in the tens of billions faces a very serious claim, and they're confident they can defeat it on the facts, they take document preservation measures to put themselves in a position to do so. We know that the decision in 2015 wasn't a slip or an oversight. It was maintained effectively for years. It was maintained, my lords and my lady, in the face, for example, of Phones for You sending a draft particulars of claim in October 2016. Those draft particulars were largely in the form then served when the claim was brought around 2 years later. For your notes, Ms. Bridge refers to the service of the draft particulars at paragraph 27 of her witness statement, which is in the supplemental bundle at page 556. In the face of that, no further instructions to preserve relevant documents were provided until March 2019, following the service of the proceedings in December 2018. As regards Mr. Alieta, the judge notes, it was even worse. He, named in the pre-action correspondence, identified in the particulars, was not told to preserve relevant documents until March 2020, which is also when a legal hold was placed on his emails. That date, March 2020, was just before the first CMC, and it was almost a year after Telefonica had filed a 97-page defense responding to the allegations. I move then to how the judge considered this issue, my final topic, and the error that we identified in his approach. Now, first, Mr Justice Roth in fact went a long way towards accepting our case on the seriousness of Telefonica's conduct and also the inadequacies of the explanations that have been provided. There are essentially 4 points on that. First, the judge found in paragraph 59 that Telefonica's conduct in relation to document preservation showed, quote, an arrogant disregard for the seriousness of the allegations made. Second, in paragraph 58, he accepted that as a result of Telefonica's conduct, some of the documentation which may well have existed is missing for one particular aspect of the claim, end quote, by which the learned judge can only have meant the allegations as regards Mr Alieta being involved in illicit contacts with Vodafone. Third, as regards Telefonica's explanation for its conduct, this was, according to paragraph 58 of the judgment, quotes, wholly inadequate. As regards the failure to instruct Mr Alieta specifically to preserve relevant documents until March 2020, there had been, quotes, no proper excuse or explanation. That comes from paragraph 303 of the judgment. Lastly, the learned judge also accepted that in circumstances where Mr Alieta was specifically identified in the Whiting note, having participated in collusive contact, quotes, it is wholly unclear when Mr Alieta was informed of the claim. That's paragraph 58. Despite those findings, my lords and my lady, in paragraph 59, the learned judge rejected Phillips's case that there had been deliberate document destruction. And it was the rejection of that allegation of deliberate destruction that seems to have played a very important part in his consideration as to whether or not to draw any adverse inference. And we say that the error was not to conclude that the document destruction was clearly deliberate. Now, in deciding whether or not to draw an adverse inference, the judge applied, by analogy, Lord Legate's reasoning in the Aphobie case. That is, of course, a case to do with the absence of a witness, but we accept that it applies also, in general terms, to the absence of contemporaneous documentation, which is a point made by Lord Justice Lewison in Volpe and Volpe. So what we have then is, yes, it is a matter for the trial judge to consider what adverse inference to draw in light of all the relevant circumstances. And yes, we accept that on appeal, absent some error of approach, or effectively a misdirection, the Court of Appeal will be reluctant to intervene. But what we have here, in our respectful submission, is a situation where a very important factor, innocence or deliberateness, was clearly crucial to the judge's approach, and in our respectful submission, he went wrong. And he didn't go wrong in his evaluation of the evidence, he went wrong in his approach to the question of what deliberate destruction meant in a case of this nature. Mm-hmm. His error, in our respectful submission, was focusing on whether the loss of Mr Alieta's documents was deliberate or innocent on the part of Mr Alieta personally, rather than the Telefonica parties. As regards Mr Alieta personally, the learned judge accepted his untested evidence that he had not knowingly or deliberately destroyed any relevant documents. And the judge went on to say this didn't mean that such documents had not been destroyed innocently. Implicit in that reasoning is that if Mr Alieta acted without guilty intention and innocently, then the document destruction should be treated as innocent for the purposes of whether or not to draw an adverse inference. That was, in our respectful submission, an error, because it was Telefonica's knowledge and intentions that were relevant to whether the document destruction was deliberate and to whether an adverse inference ought to have been drawn. And we say that, my lords and my lady, for 3 reasons. First, it is important to recall that there was never any claim against Mr Alieta. It was Telefonica, not Mr Alieta, that was under duties to preserve relevant documents. It was Telefonica that stood to obtain a litigation advantage if documents that would have been inculpatory were lost or destroyed. And it was Telefonica that would be affected by an adverse inference. Second, in this context, it was Telefonica that took the document preservation decisions, and most particularly the very serious decision in 2015 that I have been focusing on. We know that those decisions in practice rested with the most senior lawyer and other unidentified persons, presumably also senior individuals. Third, as the judge noted at paragraph 58, it was not even clear when Mr. Alieta was informed of the claim. Key disclosure custodians unwittingly, and in that sense, innocently, not knowing of a claim, destroying relevant documents or losing them, may be precisely what a party in Telefonica's position wants to achieve. So those custodians were not given, aside from Ms. Castillo, were not given document preservation warnings until March 2019 and March 2020 in the case of Mr. Alieta specifically. In that context, can I ask the court please to look at our skeleton argument at paragraph 199, which is in the core bundle, page 78. This, we said at trial, was crucial context to this question of deliberate destruction, which was that as regards the loss or destruction of documents after the commencement of proceedings, Telefonica had given in its pleadings some denials, but they were carefully limited and specific. So Telefonica pleaded that in the period from March 2019 to February 2020, various individuals were instructed not to destroy documents and that they complied with that instruction. That leaves, of course, unaddressed the gap between the service of the proceedings in December 2018 and those instructions, and all times before service of the proceedings, but after service of the letter before action and after service of the draft particulars. If we could scroll down, please, so we can see, just to note also the point at 199.2, there were certain executives mentioned in the defence, which, as I've said, is a detailed document served around a year before Mr. Alieta was given any instruction, in relation to whom no carefully framed denial was given. We could look in this context, please, to Miss Bridges' witness statement at supplemental bundle, tab 24, page 561. If we go down the page, please. At 41E, this is addressing the instruction to Mr. Alieta. And we see in the second sentence, he has also confirmed to me that he has not knowingly or deliberately destroyed any documents in his possession relating to these proceedings since he became aware of them. And as we know, the judge was not satisfied that he could even say when Mr. Alieta had become aware of the claim, if it was at all any time before March 2020, when he was given the document preservation warning. So we say, in short, that judged from the perspective of the decision makers within Telefonica and as to what they knew and intended, document destruction in this case was clearly deliberate. I've already touched on the obvious point that taking steps to preserve documents carried a negligible cost, and that sophisticated operators would appreciate that retaining relevant documents was the best way to defeat a claim that, although very serious, they thought to be weak. There are 2 points on what deliberateness means in this context. The first is shortly that although Telefonica's conduct does not appear to have extended to possibly ordering the destruction of documents, so please delete this email account, please destroy these boxes of files, a conscious decision to take no steps to preserve, and in particular not to give any document preservation notices to important custodians, is as capable of amounting to deliberate destruction as is the kind of positive decision that I've described.
Was there any evidence from Telefonica as to whether they had internal procedures as regards how long documents were kept, or whether there was document preservation generally? Because I mean, it used to be the case that people would regularly destroy documents after 6 years, or 5 years, or whatever it happened to be. I'm not sure whether that happens these days or not.
I should check. I don't think from recollection they had a specific policy that applied to all documents that they were destroyed after a certain number of years. They did refer to steps that had taken place in the relevant period that were effectively automatic. So, for example, when they migrated their email system from one provider to another, unless specific steps were taken to preserve emails, all those older than 30 days were lost. So there was something of that kind, an ordinary corporate policy or measure that if not stopped or adjusted in some way would destroy relevant documents. And of course, the practice directions, I have in mind practice direction 31B, para 7, and practice direction 57AD, paragraphs 3.1 and 4.14, make clear that the duty to preserve documents extends, along the lines my Lord has indicated, to putting a hold on ordinary corporate destruction policies or measures of that kind.
Yeah.
And that, in my respectful submission, shows that document destruction encompasses, for these purposes, a deliberate failure to prevent those kind of things taking place. So if...
Yeah.
Well, if a sophisticated party is put on notice of a claim and invited to preserve documents because of it, you can at least say that the evidential burden passes to the recipient to explain the circumstances in which, notwithstanding that, documents were not preserved.
Documents were not cited.
Were not preserved.
Yes. I mean, as you understood from my submissions, one of our principal complaints was that there was no one who was prepared to come forward and defend that decision. And we say the inherent probabilities are that when you choose not to preserve documents, it's not because you think they will show a claim to be weak, it's because you're worried that they might show it to be strong. So on that basis, turning back to failures to preserve, if Mr. Sanchez...
But if documents weren't preserved, somebody must have either deliberately or accidentally destroyed them or failed to preserve them. And as you rightly say, given the terms of the practice direction, apart from anything else, one would expect the litigant to vouchsafe direct evidence about that, if at all possible, or at the very least say the people who were responsible for this have left, and we can't get hold of them, or something like that.
Yes, I should say there were, once the proceedings were on foot, there were attempts made effectively under the control of the London solicitors then instructed to try and recover documents that may have been lost in the meantime.
Yeah.
So the course of conduct did change, but by then we say it was much too late. Not having put out document preservation notices in 2015, relying on them still being there or being capable of recovery in 2020 really isn't going to help very much and can't affect the drawing of an inference. And we, of course, know the extent of the document destruction that must have taken place in this case because of, for example, the comparison that I gave at the outset between the number of emails disclosed compared to the other parties. 300 odd out of a total of around 74,000. The second and last point on what we mean by deliberate here is we say that document destruction is deliberate in the relevant sense, where the decision maker knows that the documents at issue are at least potentially relevant to the actual or contemplated litigation. There's a detailed discussion of what deliberate means in Mr. Hollander Casey's book. It's not, and this is no criticism, it's not entirely conclusive as to where it comes out, but in our respectful submission, the threshold cannot be that the decision maker knows that the documents are actively inculpatory. One imagines how a party in FTFEU position would ever show that.
No.
And in fact, we say for two reasons that cannot be the threshold. The first is that it will almost always be impossible to know precisely how much the decision maker knew when he or she took the decision to destroy documents or allow them to be destroyed. So, for example, if the view is taken that it would be better for an email inbox not to be preserved, or for boxes of files not to be retained, then there's little incentive for that decision maker to first review the documents to see how damaging they really are. And anyone who did that review process would be very unwise indeed to make a note of what their findings were. And second, even if you did have evidence showing that the documents were known to be inculpatory, there would be little need for an adverse inference in the first place. You would rely on whatever evidence you had showing that inculpatory documents existed. Point is easy to get fuddled about. I probably fuddled it in my expression of it. But imagine in this case, if we had a file note from Mr. Sanchez saying something like, Mr. Alieta has some very damaging documents that would support FTFEU's allegations, so for goodness sake, let's not give him a document preservation notice. We would rely on that file note. we wouldn't need the inference in the first place. The purpose of the inference, my lords and my lady, is to bridge the gap between destruction of potentially relevant documents and a conclusion that those documents would have been unhelpful to the party that chose to destroy them.
Yeah.
So for those reasons, we say the learned judge erred in his approach to the key question of deliberateness. And in our respectful submissions, that means that his conclusion on whether or not to draw an adverse inference, although falling within a broad assessment as a matter of law, was essentially made on a false basis and was therefore unsafe. And the most important example of where that led the learned judge was his decision not to draw any adverse inference as regards Mr Alierta's documents and his contacts with Mr Kalau of Vodafone, which we can see, my lords and my lady, at paragraph 303 of the judgment, page 347 of the core bundle. And you'll see there, just in the penultimate sentence beginning therefore, and it's clear from the context, it's the heading a little higher up, above paragraph 296, Mr Alierta, Mr Kalau, that what the judge is doing in this section is reaching findings on essentially the illicit contacts mentioned in the Whiting note. So in our respectful submission, if the judge had taken a different approach to the destruction of Mr Alierta's documents and had taken a more robust view of what had gone on, reached the conclusion that it was deliberate destruction, and therefore not been in a position to conclude, as he did, that there wasn't illicit contacts between Mr Kalau and Mr Alierta, then it all starts, in my respectful submission, to unravel. One has that the Whiting note was at least potentially correct in relation to that contact, rather than, as the judge concluded and took into account, incorrect.
If the judge had drawn the adverse inference that you were inviting him to draw, he had to conclude that Whiting note was correct in that regard, wouldn't he?
Certainly in that regard, and that would have had a knock-on
Which, of
effect.
course, would have led to, if it was correct in the other respects that Mr McLean demonstrated a moment ago,
Yes,
then that would suggest the whole thing was correct.
indeed. Already substantially true as regards Castillo-Hum, and on this basis that the inference had been drawn true also as regards Alierta and Kalau. Now there is a much lesser inference or step that we submit the judge ought to have taken, even if he wouldn't go as far as to draw that inference, and that is simply not to allow Telefonica to rely on the absence of relevant documents at trial. Now it's one thing to not draw an adverse inference, but another to allow a defendant that has destroyed relevant documents to say in response to allegations, well, that allegation is no good because if it were good, there would be internal documents revealing.
Is that the point that's about the Alierta Kalau?
It would apply, yes. I mean, what you would have is you would obviously have Mr Alierta's own documents. You would also have documents from other disclosure custodians shedding light on what Mr Alierta knew, had said, had been told, much in the same way as I say with the Talbot Air email. But if I could just give I'll just give you the reference, given the time. But we give an example at paragraph 203 of our skeleton argument, which is core bundle, page 80. I think if I can just invite the court to read that example rather than me taking you to the underlying parts of the judgment.
Yeah.
So in our respectful submission, at a very minimum, that is not something that Telefonica ought to have been permitted to do in the circumstances of its document destruction.
Yeah.
As to where this ultimately takes us, I mean, obviously if there is to be a retrial as a result of one or more of the grounds before the court, it's crucially important that the judge at the retrial directs him or herself properly as to the meaning of deliberate destruction, therefore whether this destruction was deliberate and what consequences it has. Beyond that, it's very difficult to say. As my Lord the Chancellor has indicated, these findings are all interwoven, one relates to the other. And if my learned leader, Mr McLean, KC, has persuaded you that some parts of the judgment are unsafe, they may well interrelate with the parts of the judgment also affected by this adverse inference.
Yeah.
Those are my submissions on that point.
Thank you. Thank you very much indeed. Right.
Give me 1 second. I'll just
Yeah,
get ready.
absolutely. Yes.
My lords, my lady, as you know, I appear on behalf of the 2 Telefonica defendants in O2. The way we intend to address you is not for me to stand up and say everything I have to say on all the grounds. We're going to address you ground by ground. Hopefully that will make the submissions more focused. And I'm going to begin, obviously, with ground 1, which is the landmark lunch.
Yeah.
The judgment found that there was no concerted practice as a result of the landmark hotel meeting for 2 reasons. The first reason was that Mr Dunn's statements were not sufficiently precise. Sorry. That Mr Dunn's statements were not sufficiently precise to be able to give rise to a concerted practice. And that's dealt with at paragraphs 205 to 208 of the judgment. If we could take up the core bundle at tab 18, page 320. The relevant section.
Yeah.
Paragraph 205 to 208, and you've already seen the conclusion at 208 on this particular issue or finding. Here, by contrast, Mr Dunn's references to taking unilateral steps or claims to big cards were wholly vague, and even if understood as concerning some actions to reduce reliance on indirect retailers, it was wholly unclear what those steps or cards might be. In my judgment, this cannot reasonably be seen as having benefited EE by removing uncertainty as regards O2's strategy or conduct in the market. And that's the point that I am going to address you on, the certainty point or the lack of certainty point. The second reason why the judge found there was no concerted practice as a result of the landmark meeting was that Mr Dunn could not have inferred from Mr Swanty's behaviour any form of acquiescence or consensus to cooperate. And that's dealt with at paragraphs 209 to 218 of the judgment. And Mr Pickford for EE is going to address you on that particular finding. So let me focus on the certainty point, and let me begin by establishing what the relevant legal principles are. If we go to page 319 of the judgment, paragraph 202, you'll see the basis of the allegation that was made under the heading analysis. Does this give rise to an infringement of competition law? Fornsview alleged that it constituted a concerted practice in the form of an exchange of confidential information amounting to an infringement by object. So this was a by object case, and as I'm sure the court is well aware, both Article 101 and Chapter 1 of the Competition Act distinguish between restrictions by object and restrictions by effect. And a restriction by object is one which, by its very nature, can be regarded as harmful to competition. And the paradigm example of a by object infringement is price fixing.
Yeah.
And the concept of a restriction by object must be interpreted restrictively. And let me just show you the principles that apply. I'm going to take you to an Advocate General's opinion, not because I don't have a better authority, it's just a good summary of what the authorities are. There should be nothing controversial there. It's Authorities Bundle 13, tab 56. So this is the opinion of Advocate General Rantos in a case called Banco BPN, basically colloquially referred to as Portuguese banks, delivered on the 5th of October 2023. And I'd like you to look, please, at paragraphs 27 to 30, which are at page 3218 of the bundle. And I'd invite you to read paragraphs 27 to 30.
What's the authority cited at footnote 15? Can we just go down the page?
It's generics. It's a Court of Justice
It's a
judgment.
generic
Sorry, on the
judgment.
page.
Yeah. Okay.
Yes, case C30718 generics.
Yeah.
Court of Justice judgment. None of these principles are controversial.
No, I understand.
And I'd like to draw your attention to two particular points here. First of all, the nature of an object restriction is that the conduct is, by its very nature, regarded as being harmful to competition. So there is no need to establish the actual or investigate the actual effects of the conduct. And secondly, in paragraph 30, the concept of restriction of competition by object must be interpreted restrictively. So that's those are the principles in relation to object or effect, and the allegation in this case was an object allegation. In relation in particular to the exchange of information, in our submission, the basic principles are as follows. The exchange of information between competitors, even the unilateral exchange of information, may give rise to an infringement of competition law. However, the case law establishes that not all exchanges of information, or even exchanges of confidential information, constitute restrictions by object. The information provided must be sufficiently precise to reduce or remove uncertainty as to the strategic conduct of a competitor on the market. And I'll now take you to the cases which establish those principles. The first case is Authorities Bundle 13, tab 54. And Mr McLean has already referred to this authority. It's the General Court judgment in Nishikon,
Yeah.
T34218. If we could turn, please, to page 3120. You were shown by Mr McLean paragraphs 105 to 112. We invite you to refresh your memory as to what those say. And those paragraphs set out the well-established principles in this area. Again, none of these principles are controversial. One sees them time and time again in the relevant cases. I'll show you to a certain extent that. The paragraphs I want to focus on for the purpose of my submissions are paragraphs 107 and 108. The Court of Justice has therefore held that the exchange of information between competitors is liable to be incompatible with competition rules if it reduces or removes the degree of uncertainty as to the operation of the market in question. That's a necessary condition for an infringement. At 108, in particular, an exchange of information which is capable of removing uncertainty between participants as regards the timing, extent, and details of the modifications to be adopted by the undertakings concerned in their conduct on the market must be regarded as pursuing the anti-competitive objectives. So you'll see there, and we'll see it in the other case I'm going to take you to, the need for a certain amount of specificity in order for the condition that there is a reduction or removal of the degree of uncertainty as to the operation of the market to arise. The certainty, there's an obvious link between those two paragraphs. Now in Nishikon, the nature of the information was sufficient to be capable of giving rise to consultation. The best place to see that is actually in the appeal to the Court of Justice. That's the next tab, tab 55. Go to page 3193, please.
Before you leave 107, 108,
Of
you
course.
said that that's authority for that there needs to be a degree of an amount of specificity. Where exactly do you get that from?
So I get it from the fact that, first of all, in order to be an infringement, there must be a reduction or removal of a degree of uncertainty as to the operation of the market in question. And then I accept that the 108 says in particular, but isn't saying only in those cases, but I'll show you through the further cases, I say that's a principle that applies. But Maud, if you're asking me the question about the words in particular, I absolutely accept that.
Okay, so we're into Nishikon in the...
Sorry, but
No, it's fine. This is
before
fine.
we go, Mr McLean placed a lot of weight on the word capable, which appears in 108 and not 107. What do you say about that?
Well, it's well established that in order to have an infringement of Article 101, the alleged measure or the relevant measure has to be capable of having an effect on competition. And so one finds, for example, in effect cases, the regulator or the court will sometimes say what occurred was capable of having an effect on competition, and that's sufficient. It's slightly odd in an object case, because in an object case you don't have to look at whether it was capable of or actually had an effect, because you are dealing with a type of conduct which is presumed to have an effect on competition. Yeah. So capability absolutely is very much part of competition law. But
if it's,
really
if it's an object case, which this is, then that doesn't really come into...
It doesn't really practically apply.
There's a presumption, isn't there?
That's right.
If you establish the anti-competitive conduct had as its object the restriction of competition, then you don't have to prove the same as you would have to prove in relation to effect.
You don't have to prove an effect, actual or potential. That's the way it is.
Okay. You're going to show us
Yes, so Nishikon in the Court of Justice.
In the Court of Justice.
Page 3193, behind tab 55. You see the heading Findings of the Court above paragraph 57 in it. Perhaps it's easy if you just read 57 and 58.
Yeah,
57. Reading it out. 57 and 58, please. And 59 makes the point we've just been discussing. So you see in Nishikon, the participants at a meeting exchanged individualized and sensitive information about future pricing and supply and demand. So that's why it was an object. Next case I'd like to take you to is HSBC in the General Court. That's tab 52 of the authorities bundle. And this is the one, of course, that the judge relied particularly on in his judgment. So you see HSBC holding is against Commission, it's case T105-17. And this case involved the exchange of commercially confidential information between traders at different banks. We don't want to get into all the details. If we can go to page 3025. Paragraphs 59 to 62, you'll see if you quickly read through those paragraphs, they set out the same basic principles that we saw in Nishikon.
Sorry, 59 to 62.
59 to 62. So this isn't some judgment out on its own, this is an application of the absolutely standard principles. And you'll see 59 to 62 are very familiar. I've shown them to you in Nishikon. And then one has an application of those basic principles to the facts of this case. And if we go to page 3043, and if you could read paragraph 184. And you will recognise those as effectively the same paragraphs as 107 and 108 in Nishikon we just looked at. So again, we're very much in the absolute standard application of the standard principles. And certain of the contacts between traders were found to be infringements and some were not, and I'm interested in the one that was not. And if you could read paragraphs 187 to 191, this was a type of exchange that was not. So some points to note here. This was not a unilateral exchange to someone passive. This was bilateral. They were exchanging information with each other. The information exchange was confidential, but it didn't follow from the fact that the information was confidential that it was an infringement of competition law. You needed something more. And the something more, and what was lacking in relation to this particular exchange, you see at 189. The information was not sufficiently precise or detailed to make it possible to read into that conversation the explanation of a strategy.
Well, it was because they were finding there was a sort of puff, because it was just a piece of boasting by one trader to another.
Well, even boasting, it was commercially confidential information. Yeah. So the boasting involved confidential information passing. Now, in most cases, when you exchange confidential information, you're sunk. And that was the case for most of the information in this case. But for this particular information, the key in our submission is paragraph 189. Not the confidential information was not sufficiently precise or detailed enough to reveal a strategy.
Do we actually have the detail of what this conversation actually entail?
I think it's above paragraph 186. But trying to get into the details of it is going to be difficult. That's why I simply rely on the principles that I've shown you.
Yeah. Okay.
You'll see my hesitation.
Yes.
At one level, that's quite specific.
Yeah, quite.
Well, that's it. It was specific and it was confidential,
Right.
but not an infringement. But if I can say this, the requirement for certainty before you can have an infringement is entirely logical. Stand well back, Article 101 requires some form of consensus in order for an infringement to arise. If there's not sufficient certainty about what is being said or proposed, you cannot have consensus. That's the basic point.
Well,
And I should say the Commission lodged an appeal against this particular finding to the Court of Justice, but withdrew the appeal before it was heard.
Well,
the case did go to the Court of Justice on the other
I mean, I
point.
understand the principle at 189 of whether something is sufficiently precise or detailed, but speaking for myself, I just said I would have thought that what was said at 186 was sufficiently precise and detailed, and the Commission was actually dead right about it. But anyway, that's not for
HSBC are delighted you weren't sitting in the General Court. You'd have a different result.
But the point in 189 is not that the information must be precise and detailed. It's that it must be something which enables you to see that what was disclosed was a strategy.
I think that's fair.
You could have general information, nevertheless that disclosed a strategy. In some ways, very general information could reveal a very general strategy.
I understand. The key point is the disclosure of a strategy, but I'd put it this way. The strategy must be in sufficiently specific terms for it to actually affect the market or the participants.
Well, it may be sufficiently imprecise that you haven't disclosed a strategy.
Yes, I know.
But it's the strategy, not the precision, that matters.
It's the key thing, but they're not completely divorced from each other, is it?
Yeah. Okay.
And the final authority I'd like to show you is actually the judgment in the Portuguese bank's case.
Yeah, that's at the end of the same bundle.
That is
57.
tab 57. So this is the judgment of the Court of Justice. And if we can go to paragraph 61, which is on page 3282. And in our submission, what this shows is that in order for information to be strategic, and this sort of feels that I hope to say it comes back to Lord Phillips' question, in order for information to be strategic, it must reveal with sufficient precision the strategy which an undertaking intends to implement. And if you read paragraphs 61 to 65, that's what we see comes out of those paragraphs. You see, particularly the last words of 65, if you're exchanging information about the present, in order to be infringement, it must is such that a participant may infer with sufficient precision the future conduct of the other participants. So that's why I say that absolutely the core is revealing a strategy, but with sufficient precision is the way I put it on the basis of the case law. So that we say are the legal principles, and as you know, the judge applied the principles on the basis of HSBC. Let's look at what the judge's actual findings were. So core bundle, tab 18. Pick it up at page 316. And you can take into some of these paragraphs. I invite you to refresh your memory. First of all, in relation to paragraphs, you could read paragraphs 196 to 197. The factual findings about what happened at the landmark hotel are in paragraphs 196 to 200. That's the part of the relevant part of the judgment. And as mentioned in 196, you see the judge asking himself the correct question. He identifies the critical question. He finds that Mr. Dunn did refer to taking unilateral steps and playing some big cards. But then the important findings, factual findings. Mr. Swanty accepted Mr. Dunn did not say what those steps or cards were, and Mr. Swanty did not ask him. Mr. Dunn did not specifically mention phones for you. Mr. Swanty also accepted that the reference in Mr. Blendis's account to Mr. Swanty's concern about the implication of Mr. Dunn's remarks were probably Mr. Swanty's interpretation of what Mr. Dunn was saying, rather than something that Mr. Dunn expressly stated. And
I mean, he goes on to say, I mean, it's the last sentence of 197 that matters, isn't it?
I'm going, absolutely.
That Mr. Dunn didn't need to say it because Mr. Swanty understood it.
Well, I was going to say something different in relation
So, I mean,
to
if
what
Mr. Swanty if Mr. Swanty's response had been one which gave a positive encouragement, let's just say for the sake of argument, he'd actually said something which had given a positive encouragement. As I read what the judge says in 196 and 197, he would have found there was collusion.
I'm going to submit that's not the case. What I'd like to do, if you permit me, is just to go through all the relevant paragraphs. There are about 4 or 5.
I understand you're going to do that, but I'm just
Absolutely. I hear your question. I know what's coming.
I'm sure you do, Mr. Watkins.
Absolutely. But let's just look at all the evidence.
Okay.
And then we'll go to the nub of it. 197. I do not think Mr. Swanty fundamentally misunderstood or misinterpreted what Mr. Dunn was saying at the time. He's clearly intelligent, etc. But then, Mr. Dunn made no mention of phones for you, nor did he indicate that O2 were contemplating an exit from an indirect retailer. That's very important, because that would have been a revelation of strategy. We are planning to exit an indirect retailer.
But the judge goes on to say he didn't need to do that.
Well, he finds
Which says in the next sentence, isn't it?
Yeah.
Well, what he goes on to say is, I consider that he was sounding out Mr. Swanty to see whether, if O2 reduced its reliance on the indirect channel, EE might support that. So again, very importantly, the finding is not that Mr. Dunn said, we are planning to go out.
But if we did,
He's saying, if we were to go out, would you support us? But that's not an indication of a future strategy. It's asking a question on a premise that may or may not be true. And that's why the judge, having heard all the evidence, having made those findings, concludes, the fact that Mr Dunn did not spell this out in clear terms does not, in my judgment, preclude a finding that this was an invitation to collude. There need not be precision or specificity if he was conveying a message which his competitor could understand. But the invitation to collude wasn't itself a revelation of strategy in sufficiently precise and certain terms. That's what the judge is saying here. And that's what, with respect, FonesView have missed, because, for example, in their skeleton argument, they suggest that the judge found that Mr Dunn indicated that O2 was contemplating an exit. And quite clearly, the judge addresses that and finds that Mr Dunn was not saying that. He was not indicating the future strategy. And stating the obvious, an invitation to collude is not the same as actual collusion. And the next relevant part of the judgment is 199. And we've been shown this before, the reference to unilateral steps and big cards. And the judge says, Mr Dunn was, in my judgment, referring to the decision in principle to exit FonesView, which O2's exit had taken a few days before. And although Mr Swanty could not tell to what degree O2 might reduce volume through the indirect channel, and whether that would involve FonesView or CPW or both, he had correctly understood the thrust of Mr Dunn's remarks. And you find the thrust in paragraph 197, which is not that Mr Dunn was indicating that O2 had decided to depart from FonesView, but he was tentatively and in an unclear manner making the invitation to collude as described in 197.
so what the judge says earlier, he was, in my judgment, referring to the decision in principle to exit from FonesView, which O2's executive committee had taken a few days before. So what's the difference? So he's saying there, Mr Dunn was referring to a decision in principle to exit from FonesView. And he says, if you put 197 and 199 together, Mr Swanty understood full well that's what he was talking about, a decision to exit one or other of the, or possibly both, of the indirects.
My submission, what the judge is saying here is that in Mr Dunn's mind, Mr Dunn had in his mind that there had been a provisional decision by O2. But we know from 197, Mr Dunn did not tell Mr Swanty that O2 were contemplating an exit from indirect retailing. So there's a difference between what was in Mr Dunn's mind and why he was tentatively making this invitation to collude and what he actually said. And there's a specific finding in 197 that Mr Dunn did not indicate that O2 were contemplating an exit from an indirect retailing. And then the judge's application of law to those findings of fact, we find it paragraphs 205 to 208 of the judgment, page 320. And you've seen this before. The judge cites inter alia HSBC, and you see the conclusion at 208. Here, by contrast, Mr Dunn's references to taking unilateral steps or playing some big cards were wholly vague, and even if understood as concerning some action to reduce reliance on the indirect retailers, it was wholly unclear what those steps or cards might be. And then the punchline, as Lord Justice Phillips put the question to me, what actually matters? In my judgment, this cannot reasonably be seen as having benefited EE by removing uncertainty as regards O2's strategy or conduct on the market. So the judge correctly identifies the legal principles. He makes the factual findings that he does, and in our submission, that conclusion is the correct one on the law, given the findings that he made. Now, there's some other paragraphs that are relevant to this. Paragraph 217 at page 324. If you take it about halfway down, it's 1, 2, 3, 4, 5, 6, 7 lines down, there's a sentence that begins in the middle. Although I have found that Mr Dunn's remarks implied that O2 may seek by a big move to reduce its reliance on the indirect channel, and implied that he sought reassurance or support from EE, I've concluded that remarks were too vague to remove uncertainty in EE as to O2's future conduct. And I do not think that the circumstances, and that goes on to Mr Swanty's sounds, but my focus is on what Mr Dunn actually said. And then we have paragraph 225, which featured a lot in the opening from Phones for You. Paragraph 225 of the judgment on page 326 appears in a different section of the judgment where the judge is addressing public distancing by EE. If you look at paragraph 225, there are 2 points in relation to this. First of all, it does not address the separate and prior question of whether the words used by Mr Dunn at the Landmark Hotel meeting were sufficiently precise to reveal O2's strategy. It simply doesn't go to that. It's not relevant to that particular legal question. And in any event, paragraph 225 is entirely consistent with the judge's finding that Mr Dunn made an unsuccessful invitation to collude at the Landmark Hotel, but nonetheless was not sufficiently dissuaded to come back and try a different invitation. But it certainly can't be read back from the fact that he made another attempt.
But if it's
that the first was successful.
If it's an invitation to collude and it elicits a positive response, that's collusion, isn't it?
Well, that's what
if it was an invitation to tender or whatever, and it's accepted, it affects the contract. I don't understand the distinction you're seeking to draw there.
Sorry, M225.
No, I mean,
just generally.
I understand the point that 225 is dealing with is in a different part of the judgment, but I think I'm just querying the point about whether it was an unsuccessful attempt to invitation to collude.
That's what Mr Pickford is going to address you on.
I understand.
So what I'm looking at now, I say there is the first legal question is whether the information that was conveyed was sufficiently precise to reveal O2's strategy.
Understood.
And that's what I'm looking at. And the sort of straw man to test the position that Phones for You has put up, they've said, well, if Mr Swanty had responded positively to Mr Dunn's approach, that would have given rise to an infringement. And in our submission, that's not correct as a matter of law, because we've seen in HSBC that the traders actively exchanged confidential information. But the General Court found that the information exchanged was not sufficiently precise so as to reveal a strategy and give rise to an infringement. So we know as a matter of law that you cannot have consensus in relation to something that's not sufficiently precise to reveal a strategy.
Okay, well, that's probably a convenient moment, isn't it?
It's definitely convenient, given the time.
I mean, I've said earlier on 1:45 we'd start. I mean, do you all feel that we need to start at 1:45? I'm conscious that we're sitting long days. Anyway.
I was due to finish. Actually, I can. If you give me 2 minutes, I can finish, and then I think we're back on track.
That's what I wondered, Mr Hoskins. That's why I'm asking a question. Let's carry on then. And
sorry, to my research a bit. Yeah. Literally within less than 5 minutes, sure. I think I can finish.
And then we'll start at 2. Okay.
Sorry.
Unless they disagree with you, of
Well,
course.
I think my learning friends may want more time. Do you want to carry on for a few more minutes, or just complete this topic? Or I'm in your hands.
You carry on.
Thank
you carry on and see if you can finish.
So I was going to look at Phones for You's arguments. I've just dealt with one of them, which is what I've called the straw man, which is too pejorative. It's a thought. process to test the point. The next point is, in opening, Phones for You suggested that their focus in ground one is on the position of Mr Dunn taking comfort from Mr Swanty. Again, in our submission, that question cannot arise in the absence of a sufficiently precise statement by Mr Dunn revealing O2's strategy. You can't have consensus, as I said at the start of my submission, in relation to something which is not sufficiently precise to reveal strategy. It doesn't matter whose shoes you're in, it just can't happen. And the third point, again in opening, Phones for You suggested that Mr Dunn's words might have benefited EE by giving Mr Swanty comfort that O2 would never re-engage with Phones for You. And our submission is that such a suggestion is entirely at odds with the judge's actual findings, but what was said at the landmark lunch. The judge found that Mr Dunn did not tell Mr Swanty that O2 were even contemplating an exit from indirect retailer, let alone that if it did exit, it would never go back in. So, just to finish, if you uphold the judge's finding that Mr Dunn did not say anything sufficiently precise so as to reveal O2's strategy and therefore to give rise to an infringement, the second issue raised by Phone for You's ground one, i.e. how did Mr Swanty react, doesn't arise. It becomes irrelevant as a matter of law, if you accept my submissions. And equally, ground two, the question of public distancing, also does not arise, if I'm right.
Well, I think it's common ground. If ground one fails, then ground two becomes...
That's right. It's also if ground 1A succeeds, ground 1B becomes irrelevant.
Understood.
And also to...
Well, you need 1A and 1B, as it were,
to get
to get home. Yeah. Or they do. That's the point you're making.
So,
that's very helpful.
those are my submissions on that
Very
part
helpful.
of ground one.
Okay. So if we say 2 o'clock, is that going to...
If the court were willing to indulge the originally suggested earlier start, I would certainly be very grateful. I may be regretting that at 4:55.
I'm only conscious that we're going to sit till 5 o'clock, and that's quite a long...
Well, I'm in the court's hands, but...
Aren't we back on your timetable?
Yeah.
Yes, I was due to sit down.
I think we should. I think we should start at 2. Okay.